Hey, Brian Parker coming at you with another exciting video. This is titled The Showdown with Synchrony Bank. Why? This is another member's showdown with a creditor where again the member got a complete dismissal with prejudice. Remember, whenever you get offered a dismissal and they say without prejudice, you don't want that. You want with prejudice, because without prejudice means you may see that again. Now, I will tell you, in cases where I've had to get stuff done without prejudice, it never shows up again and it all goes away. But there's always that chance. In case you're wondering, a lot of the times when you get I had one, I think it was like $25,000 debt, completely wiped out, without prejudice because of a hardship, and hardship will be mentioned in this video. So a lot of times creditor law firm creditors will allow a person out of the lawsuit, debt goes away, but without prejudice on a hardship. You can apply for that, and you meet, mostly if you're over 70 and you're on Social Security, can get blood from a stone. Social Security is protected. There's no real exception, and you can't collect on with the judgment, so the debt collector will just fold. But they'll do it without prejudice in case you win the lottery or something. So that's their right. So today's today's debt plaintiff is Synchrony Bank. They're suing on not a Synchrony Bank debt, but a PayPal debt. Synchrony Bank, I think 2018, bought a ton of PayPal. There was a ton of problems because they didn't properly, I think, assign the debt of PayPal. So, and I know this, I have a very good friend that represents certain interests in the credit industry that has assured me, now that he no longer does that, that PayPal is one I should go after Synchrony Bank because there's no assignment. Anyway, I digress. The defendant is a member of killdebt.ai. The case is the collection case for breach of contract in the state of Washington. The highlights: securitization, leverage, counterclaim. I can't emphasize that enough. The more you do to mess with them, it produces leverage, as this did here. And you're going to be amazed what this guy did, including a motion for default against the plaintiff. Seriously, the result: complete dismissal with prejudice for defendant. This law firm was asleep at the switch. You'll see why. The sub-highlights are the mini Miranda in a weird place, that it was used at all is wrong, because it's a creditor lawsuit. So if you have a mini Miranda on a creditor lawsuit, how can the creditor say they're FDCPA compliant but immune, because creditors aren't under the FDCPA, but at the same time using FDCPA language to scare you? They can't. So we'll focus quickly on that. Killdebt.com and the AI prompt button is what my notes, Parker mentioned this. So the fabulous prompt button. So you've signed up for killdebt.com. We have essentially it's free. We don't charge more per se for all these things we keep adding, but the AI is right there to do all the work for you, as this member did. He used killdebt.com. But when you go there, we got a new prompt button, and it's got a little rocket ship on it. So you can just do a bland inquiry and hope you get result. But if you press the prompt, it'll expand that and tell you where to fill in your spaces so you can get a better result. It's just great. I use it. Okay, so a lawsuit was filed by Synchrony Bank. Let's just show you, it's silly, but Shazam. I don't know why I go into this because it's just silly. But in this case, look at number 4. Let's emphasize number 4, Cindy. And that says the defendant entered into a credit agreement with the plaintiff or the plaintiff's assignor. You might want to mention PayPal here if you want to do a half good job, do a job well, but they just say plaintiff's assignor. There may be a reason for that. Again, sometimes these lawyers are honest, but in a backward way. So the plaintiff's assignor was PayPal. but maybe they don't want to mention that because of all the problems. And you can see, by the way, the law firm reacted to my client, he's not my client, my member, that they realized they got problems. So I'll give you the second page. Shazam, that's the second page of the lawsuit against the member. It's a simple thing. They're asking for a breach of contract, money, yada, yada. And at the bottom, you can see complaint for monies due. That's just the way they're titling the thing in their file. But look, Shazam, at the page beginning with notice. This is something that the debt collector added on. And at the bottom, plaintiffs or attorneys are debt collectors. This is an attempt to collect a debt, and any information will be used for that purpose. That may be true, but that's a whole plate wrong. The law specifically, 1692E11, says don't do this on lawsuits. So they've made their creditor client, and you don't mess, as I said in my last video, you can lose a big client by doing the wrong things. But there's some thought that creditors know this is being done in order they can get both their immunity from the FDCPA and to put their foot on the gas with the FDCPA by using the language. But I digress. So we move on. Client then filed his answer and counterclaim. They should change counterclaim, I believe, just me, I'm the only one that believes this, to the word leverage, because it provides you with enormous leverage, especially in this case. As I said in the last video before, the average debt amount when you're being sued is about $6,000. So you can upset the apple cart if you start making the other side do work. The attorney's only getting a small percentage of each case. So if you do make him come to court and have to respond to discovery, he still gets the same amount. He doesn't get to get more amount from you. So that's a leverage maker. Got to be right. You got to be justified. You got to file it in good faith, as the case was here. So Shazam, that's the answer. And that's my old friend, first page, the preliminary statement. That's in an ADHD world, ADHD, where you give a quick synopsis of why you should win the case. Let's give you the second page, Shazam. And in this case, the client is going hard in on securitization and the Washington statutes as far as the collection statute. Washington is a great state if you're facing a lawsuit. That's the best way I can put that, regardless of the way that sounds. But you have real solid rights over it. It's the left part of the state. All right. But it helps defendants. So they're getting a lot of work from their southern state, California, as far as the regulations and the niceties for the defendant. But if that's also a good thing, if a plaintiff is attacking you wrongfully or with the wrong stuff, you have a right to have defenses. So that's the end of that political statement. If I go to the third page, Shazam, plaintiff is suing defendant for a breach of contract account claim stated with no proof of ownership of the debt or any proof that the defendant is the obligor. So when you have a card holder agreement with a creditor, you are the obligor, and the other side, Synchrony, is the obligee. It's weird how that works out. You take out a mortgage, you're the mortgagor, and they're the mortgagee. So anywho, we move on, and he filed a counterclaim. Shazam, a member filed a counterclaim, and that's the first page, but the second page is important. Shazam, just go to the second page, Cindy, it says 2 of 8. And see that number 5, on or about July 29th, helps nonprofit law firm representing counterclaimant sent a cease and desist letter to Synchrony and their address, yada, yada. And that's important because when you send a cease and desist letter, you are not allowed to be contacted again. Now, they could come back and go, we're Synchrony Bank, we're a creditor, we don't have to honor your cease and desist. But I'm sure there's state support in Washington that yes, they do. And B, they've already said that they've been assigned the debt, so they're a third party collecting on a defaulted debt. It wouldn't be sued unless it's defaulted. So they are debt collectors, especially with securitization, especially when they say we're debt collectors in the complaint, yada, yada, yada. So they kept calling him, and that's a violation of the FDCPA. So let me give you a brief synopsis of what this member did in his counterclaim. Shazam! He cited the Fair Debt Collection Practices Act, the Washington Collection Agency Act, the Washington Consumer Protection Act, statute of frauds, I've done a statute of frauds video for you, and unjust enrichment claims. That's a funny thing because that's the number 3 count of all debt collection cases. They'll do breach of contract, account stated claim, and they always throw in unjust enrichment. And here's this member turning the tables, and he's going to continue to do that as I go throughout this and throughout his litigation. It's almost like he's the plaintiff. And guess what? When you file a counterclaim, you are the plaintiff. They become the defendant, and they've got 20 days to respond to your lawsuit. So the member filed also a bunch of discovery, including, here's where it gets to be fun. Excuse me, I'm so excited. He filed request to admit. The rule on request to admit, whether it's 28 days or 30, depending on the state, if you miss the deadline, so you got 28 days to request to admit, whatever I said I've asked you to admit or reject, excuse me, you must do it within 28 days. Let's say it's a 28-day rule. On the 29th day, you file our answer. Too late, Charlie. The rules are quite clear, and the case law is quite clear in a lot of states. You miss 28 days, it's admitted. So whatever you ask them to admit, maybe you've asked, and you generally do, all the things that structure the elements of the claim that you're filing against the other side. So if you've admitted everything that you need to win the case, they're screwed, and screwed they were in this case. And we're going to find out about this showdown with Synchrony. Sounds like a wrestling. Here's that letter he sent, the cease and desist. Apparently this helps law firm, really helps people. It's a non-profit firm that helps people that are under the economic radar. Let's put it like that. The importance of this letter, and my reference to hardship at the beginning of this video, is that that's what Synchrony was advised of, that this client is on Social Security. Social Security generally, unless it's student loans, is immune from any kind of garnishment, any kind of collection activity, your bank account. So that's a debt that you should not pursue. And again, as I've said, I've had major creditors with major amounts coming after my clients. I go, hey, look, my client's 80 and she's on Social Security. What are you going to do? And they will back off, all right? In this case, I'll attach to this video a hardship counter affidavit. So if you can show hardship, usually because you're under economic radar because of retirement and that's your only source of income, you're going to get out of a collection lawsuit unless the other side's a real so-and-so. So that was what he attached, you see it, as Exhibit A to his answer and his counterclaim. So just like, as I said, the defendant had 20 days, because now the plaintiff is defendant in a counterclaim. So what did they do? The 20-day deadline blew right by, and right when you get a default, here's my rule of defaults. If I file a lawsuit and the other side misses the default deadline, I give them a couple extra days. We're all, especially as young attorneys, like, I got a default, I'm going to go default, I'm going to go to the court, and then I'm going to default, and I'm going to be a winner. Generally, if they have any kind of excuse, the court will go, yeah, you got a default, and they did that, don't worry about it. We're going to let them come in, as it should happen with you, because it's early days. So I always let the time mature. So he did, and this member, he called, he emailed, he finally got a hold of, and it's really hard to get a hold of debt collection attorneys, but he got a hold of him in the counsel. So he gave him notice, and the counsel said, I'll file it today. So here's a tip that he did that you should do. Always keep an eye on the court docket. Everything's online now. So if somebody tells you one thing, or even a court tells you one thing, go to the docket. If you filed something that's really important, go to the online court docket, and that's a codified real-time picture of what's really going on in the case. So that's what the member did, And then he called the clerk. This guy, belt and suspenders, but he's doing them a favor. The clerk said nothing was filed. They didn't answer. So after the member confirmed that there was nothing filed, he now has big leverage. How does he have big leverage? Because he can file a motion for default. So this is always being done to us. Well, with the counterclaim, he filed the motion for default judgment. But here's what he did. He did a lawyerly thing. This guy has, I said in the last video, some cojones. He's just really on top of stuff. And he did not set the hearing. He turned it around. This is what he did. Shazam. He essentially said, okay, I've got this default, and now I'm going to file the default judgment, and that's when no answer is filed. And he let the other side know. He let the other side, the collection firms, if they get popped for this, they're in a lot of trouble for money for him and trouble with his client. So he let the motion sit on the docket so the other side could see this, and that he used as leverage. Let me tell you what, I just kind of mess it up, so let me tell you what the client said. Shazam. So I'm waiting on a response to my counterclaims, and the deadline comes and goes. I contact opposing counsel, and after a few attempts, finally get through to him. He stated he will file the response. Within a few days, I checked with the clerk, and sure enough, it's not filed. And I'm skipping. After a while, I'm thinking that I should just file a motion to default judgment on my counterclaims. He should, which is what I did. I did not set the matter for hearing yet, as I wanted to use it as leverage and talk. I mean, it's all I ever say is leverage, leverage, leverage. I'm reading his words, okay? I didn't make this up. I could never get him on the phone again. After a few emails, I suggested the mutual walkaway and dismissal with prejudice. He agreed to dismissal, but without prejudice. I informed him I was not interested. Remember, I just did a video for you on the 10 things that, let's put it up there, Shazam, that debt collectors hate about you. That's what it is. And one of them is if you stand your ground. One of them if you're educated like this client clearly is, and stick to your guns. He agreed to dismiss without prejudice. I informed him I was not interested. Then set the matter for hearing. So bird in the hand. He knew the other side knew he's got this hearing. It's going to go bad for Synchrony and the attorney if Synchrony finds out. And he set it for a few weeks out. A few days before the hearing, the attorney emails and said, we'll agree to a dismissal. He drafted the motion, the order for the judge, which I signed both and sent to him. I'm just going to not read this next paragraph, but I'm going to put it up. Shazam. I'm going to give you the last sentence. I am glad to see you are me providing a much needed source of information. So hopefully some of these people, creditors, will just step up. Oh, some of these people, meaning you and I and him and you guys listening, will step up and decide to fight. Like this client did, like he got a dismissal with prejudice. Just get educated. These guys aren't rocket scientists. You know, I know a rocket scientist. They definitely are not rocket scientists. So I want to give you the takeaway with all that. Shazam. The key takeaway is leverage and stand your ground. That last video, let me put it up there again. 10 things debt collectors hate about you. Stand your ground and leverage. I can't say that enough. It's the deadlines. Deadlines are power. If you miss a deadline, the judge automatically defaults you. It's a truth, all right? They miss a deadline and nobody says anything. This just went on and on. He didn't tell the court or anything and they were still in violation. So that default that he held in his hand, bird in the hand, he said, I'm going to file this for a hearing. So he gave me a dismissal without prejudice. I'm going to file with this default. If they got a default against him, this attorney would be in such hot water. And you got to do that. As I said in that last video, you've got to hit them where their weakest point is because they wouldn't hesitate to do that to you. Also, he filed those requests to admit. The attorney missed the request to admit. In my business, if you get requests to admit, nothing else matters. You focus with a laser beam, get those freaking things answered within 28 days because your whole case is shot. this thing that you're protecting and showing the court how great you're doing and how badly they did. Because a lot of times when they send request remits to you, it's all, you agree that there's an assignment. You agree our bill of sale is the best there ever was. You agree yours $50 million. It's all stuff that if you miss, it's automatic. And now they don't have to prove what they couldn't prove in the first place. So you get that done. Every attorney knows that. And this attorney was asleep at the switch. Always verify with the clerk. That court docket, keep an eye on the court docket when you're being sued. It's a great source of information. Somebody tells you something, they may be lying. You can see what's really going on, all right? Or they say, here's a good, and I've done this. They said they served me personally. I know they didn't serve me personally. On the docket, they filed with the court saying, we served him personally. I rush to that court or do whatever I can to get that proof of service saying they did when I know they didn't. That's gold, Jerry, because they now have lied on a court document. So use that court document. He did the motion in pocket tactic. The other side knew that there was a motion, but he hadn't filed the notice of hearing. This guy's brilliant. I'd love to tell you his name, but I'm not going to do that. Demand with prejudice, stand your ground. Without prejudice is just a reset button for the bank. Collection law firms rely on default. 9 out of 10 cases are defaulted against you. This member turned that around. I want to talk to you quickly about the hardship. If you are in a hardship situation, so you've been sued, you owe all this money, but you're out of work and you can show it, you've got all these debts and you can show it, but most importantly, if you have what's called an exception, if your money is protected, it's pension, a disability money is protected, or Social Security, something from the government, they can't touch it. They're not going to invest their money, but they also don't know about it. So I've got a counter affidavit attached to this video you can use. Mini Miranda, this member didn't have to use this thing. He had so many things he could use against them, but they violated the law. So there was something else he could have used against them. So this isn't just one success story. It's proof that debt collectors are vulnerable. And when you know their weaknesses, they count on you being too scared or uninformed. So get educated, stand your ground, find your leverage, and do what this member said. And I will quote it, Shazam. I am glad to see you're providing a much needed source of information. So hopefully some of these people, meaning you and I, will step up and decide to fight. He did, and he got the whole thing thrown out. You can do that too. Will you be the next person that stands up and fights? And you can use killdebt.com, and killdebt.ai does all the work for you. And now not only does it give you all these fantastic results, killdebt.ai will allow you to rocket ship your prompt. So when you put a question into killdebt.ai, you're saying, hey, do you have this? I need an answer to this lawsuit. It'll show you how a better way to ask. So what happens is the result that comes out that you can file with the court after you add your facts and state law is better. So use the prompt, baby. Use the prompt. So I want to end this happily by telling you what's attached to this video. Shazam, the Synchrony complaint. The member's answer and affirmative defenses in Word, so you can use it. The member's counterclaim in Word, the motion for default judgments. Some of these things you may need, some of them you won't, but they're there for you. The hardship counter affidavit, if you're in a hardship position, you can use this affidavit, of course, add everything you need to. The member created publicly available documents on securitization and Synchrony Bank specific securitization. I'll attach that. It'll cut your research in half and show you where you go. He compiled a whole list of securitization approaches and research topics. So it's great. It'll give you links and everything. The member's requests of Synchrony Bank in discovery that flawed them, and also the show notes. And also, again, I'm going to throw in Parker GPT's AI response to the collection complaint, meaning It's going to guide you as to how to get everything you need to properly answer a complaint, how to file it, who to send it to, proof of service. That'll be Parker GPT's checklist on how to do soup to nuts. I don't know what that means, but it means A to Z. When you get a complaint, here's what you do using killdebt.ai. So that's it. A member did good in his showdown with Synchrony Bank. I hope this helps. We helped a member. He's now passing it forward to you. Thank you very much.